virtue of Section 1 of the Fines and Recovery Act of 1833, which says that by virtue of that, you could dispose of your interest in that land, which is entailed by way of fee simple or for any lesser estate. Remember that if you are not in possession, you need to get the consent of the person who is in possession. Otherwise, what you'll be giving out is base fee, which is less, which is giving a lesser inheritable interest. I remember that I also mentioned to you that it could happen by way of statutory conversion, which is embedded in the provision of Section 3 of PCL of 1959 of Western Region, applicable in Old Western Region, Mid-Western Region of Oyo, Osun, Ondo, Ekiti, Ogun, Edo, and Delta State, saying that there's a limitation of fee-tail estate before and then after the commencement of the law will operate as a conveyance of fee simple estate in absolute in possession. Okay, we now say that life estate involves a situation whereby the life estate involves a situation whereby a life estate life interest is created in favor of a grantee, and that it will be created by express limitation or by operation of law. It is created expressly where an estate is limited in favor of, say, John for his life, and then, or say, in favor of John for the life of Ralph. Now, I want to mention also that apart from that, creation of life estate by operation of law is that before the advent of Land Use Act, of course, what it means is that if you use any effective means on an ineffective means of creating a fee simple, will eventually, unfortunately, give you a life estate. So and now the rule in the Wild case we mentioned that is also applicable when we're talking about estate, and that it is a rule applicable in construction of a will, whereby they are saying that if a gift is given to a man, a gift of land is given to the man by a testator in his will to a man and his children, but at the time of that gift, the man had no children. Of course, what the man would take in terms of the device would certainly be, a fee-tail estate. And the justification for this rule is that, the only way the children can benefit is if the man has an estate of inheritance. However, in the case of where the children are alive when the gift was made, of course, what will happen between him and the children is what we call joint tenancy. And I said the rule in Shelley case is such that when they apply it to interpretation of a deed and a will, and then where there's a gift to a man, saying that the man will take an estate and then say, an estate, and then the remainder goes to the children. What now happens is that the rule in Shelley's case, if applied to the construction of a will or a deed, means that the said Mr. A could sell the interest and then dispose of it, without taking care or without having regard to the interest of the remainder man. Now, but I said that I also mentioned to you that this rule, this rule that applies to construction of will and deed has been abolished in the PCL state, and that in respect of all instruments coming to effect, after that date, to which, to the extent to which the words heirs or heirs of his body are construed as word of purchase. Thus, where there's a word of limitation to A for life remainder to his heirs, and then effect under the law is to restrict A's interest to life interest, and then to appropriate a definite interest to the heirs or heirs of his body of A. So what I'm trying to say is that the rule in Shelley's case has been abolished. The rule in Shelley's case says that the man may not consider the interest of the remainder man and can more or less dispose of it in a situation whereby the estate is created in his favor and the remainder in favor of his children. However, what has happened here is that the Conveyancy Act of 1950, sorry, Property and Conveyancy Law of 1959 makes this impossible and therefore abolishes it. So when that kind of estate is created, what the man will have is life estate. He would enjoy it he will have a life interest, while the remainder will go to the children. Okay, we now talk about modified estate. And we say that a freehold estate may be granted either upon a condition, or may be limited by a determinable event. So what we are trying to say here is that if it is granted upon condition, that means that they are saying that they are saying that before that estate will take place, you must fulfill some conditions. And then to say that it is limited by a determinable event means that the period for which you are going to enjoy that interest may be such that is limited by some determinable events. Now, when we say that an interest is granted upon a condition, when we say that when an interest upon a condition is that which is predicated upon an event, the happening or non-happening of which the grantee's estate may commence or not commence. So when it's granted upon a condition, it then means that the happening of that event will determine the commencement, and that the non-happening will mean that that interest may not commence or will be determined. So now, that having been said, we are saying that where the enjoyment of an interest, may not commence until some events occur. That is when the interest will not be conferred on you, when you cannot start the enjoyment of that interest until some events occur. They refer to this scenario as condition precedents. But where the interest is to be determined on the occurrence of some event, this is a condition subsequent. So a condition precedent says that unless some event happen, you cannot start to enjoy the interest in that land. The other one is, which is the opposite, saying that, the interest that you enjoy in that land, are we together, will be determined on the occurrence of certain events. And this is regarded as condition subsequent. And then we cited example of what could amount to a condition precedent. We cited example of what could amount to a condition precedent. And then we said that a condition precedent is where a gift is made to X. A gift is made to X and is X when X is 21 years old. Of course, the effect of this case is that the estate becomes only operative when the specified condition is fulfilled. And if X is unable to attain the age of 21 years, then it means that the gift will be aborted. Now, we went further to say that a gift to Y on the condition, please compare to this one. The one says that unless he attains the age of 21, then the estate cannot commence. Then this one says that on a gift to Y on the condition that he never sells out the family, never sells out of the family. It's an example of a condition subsequent. We said the condition subsequent is one that will make the estate to be determined when that event happens. But the condition precedent says that unless that condition happens, the enjoyment of that estate cannot start. While condition subsequent says that the estate will determine, the interest will be determined if that event should by any reason occur. So now, in the first example of unless you attain 21, that's a condition subsequent. And in the example of a gift to Y, on the condition that he will never sell out of the family, is an example of a condition subsequent. Condition subsequent says that as soon as that event happens, then your enjoyment of that interest becomes determined. Why condition precedent says that until that condition occurs, until that event occurs, then it then means that that estate, that interest, you cannot start enjoyment of it. So now we move on to say that what that means is that the land passes to Y in this condition subsequent example that we are giving to you. The land will pass to Y upon the creation of the interest, but it is liable to be forfeited if the condition is broken. So it will forfeit that interest as soon as the condition is broken. That's an example of an estate created based on condition subsequent. Okay, why is therefore has a vested interest liable to be divested when the condition attached to his interest operates in future to defeat his interest? So simply put, what we're saying is that if the thing is condition precedent, then it then means that the event must occur before you can start the enjoyment of that interest. If it is created based on conditions subsequent, you will lose the enjoyment of that interest. The interest that you have in that land will become determined if that event should occur. And example given in A relating to condition precedent is that he must attain 21 years before the enjoyment of the interest will start. While the example given in the subsequent condition subsequent is that he must not sell it out of the family line. As soon as he sell it out of the family line, then the estate becomes the interest will cease. So we now say that there a distinguishing feature of an interest upon condition is the presence of a separate clause of disfeasance. Are we together? A separate clause of disfeasance. When look at it, it says that there's a separate clause of disfeasance, which is that it can stand on its own and it can easily be detached. Some of those clauses that can operate as a separate clause of disfeasance, they include something like provided that. Are we together? Provided that, on the condition that, but if it happens that, and all of this will operate as condition subsequent. Now, the test usually is whether the defeasible condition is external to the words of limitation. So what I'm trying to say in essence is that a distinguishing feature of an interest upon condition is the presence of a separate clause of disfeasance that stands on its own and easily detached. Of course, the clauses like provided that, on the condition that, but if, and then if it happens that, they operate as conditions subsequent. So now, let me go further to elaborate. When we say that something is a separate clause of disfeasance, then it then means that it can stand on its own. If it is inseparable, it then means that it has to be part of it. It is usually inseparable when we are talking about condition subsequent. So, but as we go on, you will see the examples I'm going to lay before you to be able to know when this clause is a separate clause of disfeasance and when it is not when it's a clause of inseparable, is an inseparable clause of disfeasance. So please note as we're going on that there are some examples I'm going to give to you. They operate as a separate clause of disfeasance, and the other one will operate as inseparable clause of disfeasance. So the things that you're to look out for in this part of this lecture as we move on now is that there are some clauses that would more or less operate as separable clause of disfeasance, while some operate as inseparable clause of disfeasance. Then the function of the ones that are separable clause of disfeasance, I will let you know. The functions of the ones that are inseparable clause of disfeasance, you will get to know. Now, please just come along with me. Are we together? Hello?
Yes, sir.
Are we there? Okay. Now, when we say that an estate, or interest is upon condition. The author is telling us that it gives the grantor right to re-enter. It gives the grantor right to re-enter and determine the estate when the events occur. When we say an estate or interest upon condition merely gives the grantor a right to a right to enter and determine the estate when the events occur. I.e., what is telling us that when this is the case, they're saying that the interest is not void ab initio on the failure of the condition, but only voidable at the discretion of the grantor. So when there's a failure of the condition, they are not saying that that estate will be void ab initio. What they are saying is that that estate will give the grantor right to do what? To enter the premises or to enter and determine the estate. So the failure of that condition that is set for the happening, for taking of that interest, if it fails, does not mean that that estate will be void ab initio. It becomes voidable. It becomes what? Voidable at the discretion of the grantor. At the discretion of the... Hello, who is that? So when a condition is set for an estate to take effect, and that condition, there's a failure of that condition, they are saying that the author is saying that, oh, who is there? Who is that person? Who is this person? Please, can somebody tell him to get to mute his microphone? Hello? 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 Hello?
Yes, sir, we can hear you. Someone will text him now.
Somebody is not muted among you. So please, I want to follow me that we should note that there are some clauses that are separate clause of disfeasance, and there are some clauses that are inseparable clause of disfeasance. We're going to learn them as we go on and what they achieve. Now, we're not saying that if there's a failure of condition, that does not make that estate to be what? To be void ab initio. He said it will become voidable at the discretion of the grantor. Now, it goes further to tell us that failure of that condition would have another consequence, apart from the fact that it makes it voidable and not void. It has another consequence. Another consequence that it has is that who is this person now?
Please mute
this person to mute himself.
Today, let me pause. Please mute your mic.
Okay, thank you. So we're saying that failure of that condition now makes it voidable, make it voidable at the discretion of the grantor, not void ab initio. And a failure of the condition will normally vest the interest in the third party that is stipulated in the instrument creating the interest. Are we together? It does what? It will be vested in the third party that is mentioned in that instrument that is creating the interest. So two things I've mentioned here. As we go on in the course of this lecture, we need to look out what will amount to separable clause of disfeasance and what is inseparable clause of disfeasance, and what is the consequence of each of them. Now, I now mention that when there's a failure of condition, Now, what will happen is not to make that estate void ab initio. It is to make it voidable at the, at the, at the discretion of the grantor. And then what that means is that, he could enter and determine the estate, when this event of failure of condition has happened. And another example, another consequence that follows is that, when that failure happens, what happens is that the interest vests in the third party, that have been so mentioned in that instrument, and it will not automatically go back to the grantor. Now, we now come back to a determinable interest on the other hand. The determinable interest on the other hand. Come back to determinable interest on the other hand. Now, when we talk about determinable interest, now it says that one on the that one on the other hand is saying that when determinable interest is in issue, now the occurrence of the specified event means that, the occurrence of specified event means that for example, we say, we grant to Mr. John and his heir until a specified lease was made, or K and his heirs, as long as such a tree stands, it then means that determinable interest is created. Now, take for example again, I will repeat myself. It says that the estate of J comes about. Are we together? Sorry. The estate of J and K may continue forever, but if the specified state of affairs come about, then the fee will become determined and the land will revert to the original grantor. The first thing I need to let you know is that, one, look at it from here. We say that an estate or interest upon condition may give the grantor a right to enter and determine the estate when the event occurs, such as the failure of condition, but it will not be void ab initio, but it will be what? It will be voidable at the discretion of the grantor. Failure of condition here, when we talk about interest upon condition, failure of the condition will normally vest the interest in the third party that is stipulated in the instrument that is creating the interest. Now, in the determinable interest, on the other hand, it is saying that it will automatically determine on the occurrence of some specified event which may never happen. The occurrence of some specified events which may never happen will determine the interest when we talk about determinable interest. Interest upon condition and interest that is a determinable one. The distinction between interest upon condition and interest that is determinable is that if it is interest upon condition, it will give the grantor, the right to enter and determine the estate. In the event that there's a failure of condition, it will not make it void ab initio. It will make it to be voidable at the discretion of the grantor. Failure of the condition normally will vest the interest in what? In the third party that is stipulated in the instrument that is creating the interest. Okay, now compared to a determinable interest that we're talking about here, when we talk about a determinable interest, on the other hand, this will give rise to automatic determination of the interest on the occurrence of some specified events which may never occur or which may never happen. I repeat again, in the first instance, when there's a failure of condition, the interest does not automatically go back to that person. It will only give him right to enter and determine, and then will not treat that estate as void. It will treat it as voidable. Voidable means that you can take steps to avoid that contract in the course of time. Now, if it is a determinable interest, on the other hand, what will happen is that it will automatically determine that estate on the occurrence of some of those events that have been specified. But that event that we're talking about may never happen. The event may never happen. So now we gave examples to illustrate. We said that if a grant is made to J and his heirs until a specified lease was made, that's an example of a determinable interest. It's an example of a determinable interest. Now, another example, to K and his heirs, as long as such a tree stands, as long as such a tree stands, as long as such a tree stands, will create what? Determinable fee. Are we together? It will create what? A determinable what? So when you hear something like as long as, what you have seen there is a determinable fee. It's a what? It's a determinable fee. When you hear something like unless something happens, you cannot start the enjoyment of the estate, then it's a condition. It's an interest upon condition. So now when we say that it's a determinable interest upon condition, interest that is determinable, they are different to the extent that the one that is upon condition says that as soon as there is a failure of that condition, the estate, that interest is not void, it's voidable at the discretion of the grantor, and that the failure will not automatically vest the interest will automatically vest the interest in the third party that is mentioned in that instrument. But here, determinable interest says that when that event that has been, that has been specified, if they occur, then it then means that estate becomes automatically determined. Though the event may never happen. So examples like to J and his heir, are you getting my point? To J and his heir until, of course, now to K and his heir, as long as, are you getting my point? So if you say something like to J and his heir, as long as, they will create determinable fees. Determinable what? Determinable fees. So now, that having been said, the estate of J and K, what happens here is that in that example, say to J and S until to K and his heir, as long as, what happens is that to J and Mr. K is that both of them may continue forever. They may continue forever, but if the specified state of affairs comes about, then the fee will be determined and the land will revert to the original grantor. Here, remember, they say that in interest upon condition, the interest will not be void, it will become voidable. It will go to the third party that is stipulated in the instrument, and then whereas in this case that we mentioned here, it will automatically determine, and then it will revert to the original grantor when we are talking about determinable interest. So now it is important for us to know, therefore, that the fact that grantor has not stipulated that the estate shall pass on to another person upon the failure of certain event, but back to him makes the interest a determinable one. So in a circumstance where the man has not stipulated that an interest should go to a third party, but that the thing should be reverted to him when it fails or when that event happens, makes it to be a determinable interest. So two things that you need to note from these two paragraphs that we have discussed since we started is that for interest that is created upon condition, failure of condition will mean that that thing becomes voidable at the discretion of the grantor, and it gives him right to enter and determine the estate. The failure of that condition usually will vest the interest in a third party that has been stipulated in the instrument. However, I also let you know that discernible interest is such that we would say that we'll grant to J and his heir until so, and then we'll grant to K and his heirs, as long as, when you see clauses like this, what you are seeing is saying that you have created a determinable fee. The determinable fee has been created. And then what that means is that K and J can continue forever if the stipulated state of affairs, they can continue to enjoy it. But if those stipulated state of affairs, if they come about, then what it means is that the fee will be determined and the land will revert to the original grantor. So that having been said, now we are coming to divisible. What is divisible and not what is not divisible. Now, unlike the an estate upon condition is usually characterized by use of an inseparable clause of disfeasance. Inseparable what? Clause of disfeasance. So if the terminating event is an integral part of the formula from which the size of the interest is to be calculated or ascertained, then a determinable fee is created. Thus, expressions like until, as long as, while, during, they operate to create a determinable fee. So examples like provided that, on the condition that, they are all creating a condition, an interest upon condition. And examples like provided that, on the condition that, they are separable clause of disfeasance, which are applicable to interest upon condition. They are applicable to interest upon condition. Examples that are qualifying as inseparable clause of disfeasance, like when we say until, as long as, during, while, they operate as what? As determinable fees. So I'm going to summarize what I've mentioned here. What I mentioned here is that one, when we talk about interest upon condition, now what is applicable is a separable clause of disfeasance, which looks like, provided that, on the condition that. Now, the effect of this is that when the condition fails, now the property does not automatically revert to the grantor. It is going to revert to the third party that has been mentioned in the instrument creating the interest. And then it does not make that interest to be void ab initio. It only makes it to be voidable, giving the grantor right to re-enter and then determine. Whereas if we compare it to the determinable interest, they are saying that clauses that will show that until, as long as, they are more or less creating a determinable interest, showing that the K and J in our examples can continue forever. But if the specified state of affairs come about, then the fee will be determined and the land would do what? Would revert to the original grantor. That is the position of, of determinable estate and then determinable interest and then interest upon condition when we talk about doctrine of estate. Now, when we talk about determinable fees, what happened is that the clause of disfeasance, they are inseparable. They will not be separable. An example is until, are we together? And during, while, as opposed to provided that and on condition that. So now, another thing that I need to let you know is that another thing that I know, upon the occurrence of events specified, of course, a determinable interest, unlike an interest upon condition, becomes automatically void, so that the grantor does not need to re-enter before the interest is determined. So, in interest upon condition, the grantor has to re-enter before the interest is determined, because the failure of that condition does not make it to be void, it makes it to be voidable until the grantor enters, and that the interest will go to the third party mentioned in the instrument creating it. So, as opposed to, the determinable interest, which more or less become void, it becomes determined immediately that event that is specified has happened. Like we have mentioned here, in the case of J and K, if that event happens, if that state of affair comes to be, then the interest becomes determined. It becomes determined, and then what happens is that the estate reverses automatically. In a determinable fee, determinable interest, you don't need to re-enter before the determination takes place, before the estate reverse. So now we also show that in a determinable fee, therefore, there cannot be a remainder by virtue such as remainder. So they will say that there is no remainder. It is only on condition. It's only interest based on condition that you can have a remainder. any clause that is providing for remainder in a determinable interest would be a void clause. Are we together? It refers to the grantor upon the occurrence of that specified event. It will revert to the grantor upon the occurrence of the specified event. Are we together?
Yes, sir.
Okay, so
Sorry, sir.
wait, I'm coming. Let me add this one. Now, what happens is that if the occurrence of the determining event becomes impossible, then the possibility of reverter is destroyed, and then the interest will become what? Absolute. So, for example, where they say that A, and it's yes, until B marries, and B dies before getting married. This dies, in fact, B dies as a bachelor. So the summary of what I'm saying is that upon the occurrence of events specified, a determinable interest, unlike the interest upon condition, becomes automatically void, so that the grantor dies, so that the grantor does not have to re-enter before the interest is determined. It doesn't have. There cannot be a remainder, because a proviso that is talking about remainder is void, and that the estate will revert to the grantor upon the occurrence of that event that is specified. Occurrence of the determining event, where it becomes impossible, then the possibility of reverter has been destroyed. It has been destroyed when we talk about, and then the interest becomes absolute, because it is impossible for that specified event to happen. For example, when we say A, and A and its heirs would continue to enjoy until B marries, but B dies as a bachelor. What has happened is that the specified event is impossible, cannot happen again. If it cannot happen, it then means that the possibility of reverter will be destroyed. Reverter that should happen in respect of determinable interest becomes destroyed, and then what happens is that person who is supposed to enjoy a determined interest will now enjoy an absolute interest. I repeat myself that determinable interest will have inseparable clause of disfeasance, such as until, while, and during. And the effect is that when that determinable event occurs, the interest determines automatically, and then it's reversed to the third party. There is no provision for a remainder in a determinable interest. If any clause is there that is suggesting to say that there's a remainder, remember also that if the okay, please, hello, I'm sorry. Hello, please, can you ask your question?
Oh, thank you, sir.
Hello?
Sir, yeah. Sir, can you hear me?
Yes, I can hear you.
Okay, yeah, thank you, sir. Earlier, you mentioned something along the lines of where the interest or something provides for a retainer or for a remainder, rather, it should be void. I didn't really understand what you meant by that, sir.
Okay, remainder.
Yes.
Okay. Remainder, they must have taught you something like that in trust and in equity. When we say, you remember when I was talking about Shelley's case, I said the application of rules in Shelley to interpretation or construction of a will says that if a life estate is created in a man and a remainder is given to the children, the remainder means that the person that should take the remaining part of the estate after you are gone is the remainder man. Did you get that? Hello? Hello?
Yes, sir. Yes, sir.
Okay. You remember I said, if a life estate is created for a man, if a life estate is created for a man, and then the man, now the rest of the estate after he's gone is created for in favor of his children, then the children will be the remainder men. The children will be what? The remainder men. The remainder of the estate means that in that scenario that I've created for you, after the man has lived and died, the remainder goes to who are indicated in that instrument creating the interest as likely to take over after him. So those persons are referred to as the remainder man or remainder men. Now, we're not saying that anything that is said to be conditioned or that is said to be determinable interest, that is said to be in the nature of having the nature of inseparable clause of disfacers, cannot have a clause referring to the remainder man. Any clause in it that is referring to remainder man will be void. That is the point I'm trying to pass across to you. Did I make myself clear?
Yes,
Hello?
sir. Yes, sir. Thank you, sir.
Okay, can I move on? There are some void conditions that can never be in such interests that we've been talking about. Number one of those void conditions, they include that where it is, some of the conditions that will be repugnant to interest granted, condition that will be repugnant to the interest granted, they'll be considered to be void. Number one, where a condition attached to a fee simple creates, some restrictions or limitation, and then it creates some restrictions or limitations on the complete freedom of its enjoyment. You remember that we said fee simple is more or less, something that gives you right to create something less than it in favor of the third party, or possibly, dispose of it. So anything that restricts or limits your complete freedom in the enjoyment of this, of these rights created under fee simple, it will be tantamount to a void condition. And then it shows that condition that, that the grantee shall always let the land, for example, it will let the land as a definite rent, or prescribes that the use to which that or to prescribe the use to which the grantee will put the land, or where it deprive the grantee the power of sale. All of these conditions, they are considered to be repugnant. They are considered to be repugnant to fee simple. They will be deemed as void conditions. So when you are granted this kind of estate, and then that condition is still being put there to say that, I will restrict, or that will limit your complete freedom in respect of the enjoyment of that estate, then it will be void. It goes further to say that if a condition is saying that subject to, in relation to the fee simple that you're enjoying, then we are more or less going to be letting it out at a definite rent that we're going to be dictating or stipulating for you. Then it is repugnant to the interest that is granted, and it will be void. It goes further to say that if it deprives you the power to sell, that is even worse still. It will be void on the ground that they are incompatible with the complete freedom of the enjoyment and disposition of, and the management of that property. So now you can see Cockrell. Are we together? Are we together?
Yes,
Hello?
sir.
Okay, for those, no, please let me take you back. For those, for our discussion on what's it called, on interest upon condition. See Hollis Hospital's case. Hollis is spelled HOLLIS Hospital's case. See also Macleay. Macleay is spelled MACLEAY. See also Wine and Fletcher. See Wine and Fletcher. Are we together? See Wynne and Fletcher. Wynne and Fletcher is spelled WYNNE against Fletcher. See also Reed Evans. Reed Evans contract. See Reed Evans contract. Reed Evans contract as pronounced. See also the case of Reed Acosta. See Reed Acosta. See Reed Acosta. Are we together? See Reed Acosta. Are we together? See Reed Acosta. Is that clear? See also Matthew Manning's case. See Matthew Manning's case. See Matthew Manning's case. Matthew Manning's case. Now, for determinable interest that we have started, we discussed also. Manning is spelled MANNING's case. Then, for determinable interest that we have discussed so far, see the case of Idle and Cook here. Idle and Cook here. No, sorry, Idle and Cook rather. Is Idle and Cook? Idle is spelled IDLE and Cook is spelled COOK. COOK. Now, you can also see the case of Lewis and Lack. Lewis is spelled NEWIS. Lack is spelled LARK. Then you can also see Blackman and Fish. Blackman is as pronounced. Then Fish is spelled FYSH. FYSH. So now those conditions that we are talking about will be void. Example of so those examples I've cited to you will show that such things will be void, and you can see the case of Recockrell to attach it to when we say that where a condition is repugnant to interest granted. So those void conditions include where it is repugnant to the interest granted. Where it is repugnant to interest granted is where they are limiting or restricting your complete freedom of its enjoyment, and thus any condition that is saying that grantee must rent at a definite rate, or that it prescribes the use to which the grantee will put the land, or that it says that the grantee does not have the power to dispose or sell, it will be void on the ground of its incompatibility with complete freedom of enjoyment and disposition and the management, that the law attributes to the ownership of such estate. And then you can see the case of Recockrell. See Recockrell. And then that having been said, another voidable condition when we talk about, in such estates at like Fee Simple is where it is directed against the cause of devolution. It is directed against the cause of the devolution. You can see the case of Remachu. Maku is spelled R-E, then Maku is spelled M-A-C-H-U. Now, what do we mean by when it is directed against the cause of devolution? If the cause of devolution that is prescribed by the law, cause of devolution that is prescribed by the law, such as where the conditions render a Fee Simple estate liable to be defeated. If it render a Fee Simple liable to be defeated, if the tenant dies intestate, becomes bankrupt, or has, the estate size in execution, because the reason why it will be void is because law has prescribed in each of these events that estate shall develop in a particular way. So when you have a Fee Simple estate that is saying that, that is directed against, cause of devolution that is prescribed by the law, such condition will be void, because example of such condition is that where it renders a Fee Simple liable to be defeated if tenant dies intestate or becomes bankrupt, or that if the estate is sized in execution, that it will become what? It will become void. Then it means that clause is void, because law has prescribed in each event, that the estate shall develop in a particular way, and that is the case of Remachu. That is what Maku is telling us. Now, another thing that we need to note is that now, please note very importantly that a condition which also conflicts with the general interest of the community, or has a tendency to do something okay, has a tendency to do something that will not necessarily, I'm coming, please let me state it again. A condition which conflicts with the general interest of the community or has a tendency so to do something that it will not necessarily do so is void. So now what I'm trying to say is that if a condition, for example, says that if that other part of the grammar is too much for you, it's okay. Just say a condition which conflicts with the general interest of the community. So close to. Oh,
Sir,
sorry.
we cannot really.
Okay, yes, I'm sorry. I lost contact. So I'm saying that just note that the third condition that will be void, if it is attaching to fee simple, is that a condition which conflicts with the general interest of the community. For example, a condition that has a tendency to promote what? Celibacy. If that condition promotes celibacy, are we together? It will be void though. It will be void. You can see Jones and Jones. You can also see Allen and Jackson. You can see Allen and Jackson. Now, when the condition is also, instigating divorce of spouse, the divorce of spouse, it will also be void. See the case of remor. Remor is spelled R-E, then M-O-O-R. Then if it is restricting freedom of religion, it will also be void. See also Blathwayt, and then Lord Colley. Blathwayt and Colley spelled Blathwayt, and then Lord Colley spelled Lord, and then Colley spelled Cawley. So if also the condition is more or less is uncertain in either an expression or operation, it will be deemed to be void. So thus, if there is a provision that an interest should be forfeited if the donee visited any of my present wife or my nephew or niece or have social or other relationship with a new person, they'll be void. They'll be void. They'll be held to be void, since it is possible to say with reasonable certainty which of the certain connections included in the word. So summary of what I'm saying here about void conditions, that where it is proportional to interest granted, then it will be void. Where there's a clause, attaching to fee simple, where it is directing against cost of devolution, or where it is more or less is in conflict with the interest of the community, or is a condition which is uncertain. All of those circumstances will lead to, that clause being considered to be void. When we talk about condition not certain or uncertain in expression or operation, you can see the case of
Only on my Zoom physical on the 15 and the 16. One if you go say. Physical is not very Zoom. She be exam here. I don't question class. I'm year 3 nìkan.
Akintunde Akinfewa mute mic.
Match.
Okay. See Jeffrey and Jeffrey.
So listen by saying cost of oil and new first cost for the February,
Let it
cost
go
of
keep
March,
quiet.
then made in
To mute.
April.
To be muted.
Hey, yeah. So calculate face criminal law buying.
Tolu Alashe,
Criminal law
Akiyemi, please, can you mute the person speaking?
Oh yeah, no more.
I think the host has moved to you.
I'm on Jimmy Kemi. This is more consulting. I've tried to test it. She test and go, but test it once. I only get we test land. So this is why I see. Ultimate delay was February here. The April.
Akitunde Akifewa, please mute your mic.
Akitunde Akifewa, mute your mic.
That's me start to I mean. Also the meta.
I think Oluwase Akiyemi is an host. You can mute him.
Akin, mute your mic.
Akifewa, please mute your mic.
Okay, don't worry. Let's go on. Okay, now when we talk about creation of who is this person now? Let him keep quiet.
Tolu Alashe, Akiyemi, you're an host. The host role has moved to you. Can you mute him? Sorry about the disruption, sir. It's been muted.
Sorry. So those cases. So I was citing Jeffrey and Jeffrey to support the situation whereby the condition, is either uncertain in their expression or in their operation. Now, when we talk about creation of estate under our local statute, now what happened is that briefly, let me explain to you the summary of what is there that I need to let you know. That the other states outside PCL, good afternoon, sir. Other states outside PCL, good afternoon, sir. Yes, sir. Okay, can I? You want to ask me something, sir?
No.
Okay, I'm sorry. Okay, the other states outside PCL, they have amended their statutes in a way that when we are talking about fee simple, fee tail or something, what they have used to substitute this is right of occupancy in conformity with what the land user has actually prescribed. Are you getting my point? Whereas it is unfortunate and then it sounds somehow funny that the Western region and the Midwestern region is always the forward-looking. That's always always at the forefront of amendments of revolutionizing their law. They have not made those amendments in the PCS state. And then what has happened is that even though they say that, even though they have not made this amendment that will substitute right of occupancy for doctrine of vesting in view of the enactment of land user, nothing is lost. Nothing is lost because the provision of land user is in section 48 is that it will amend any other law, I get to my point, that is in existence at the time that land use act is enacted to conform with the intendment and the provisions of land use act. Therefore, even though we have not amended PCL to remove those things like those old jargons that we inherited from England, from the British people, the land use act will force them to be amended to be in line with the provisions of the act and the provision in line with the intendments of the act itself. So they say that. So if you now begin to still grant anything like fee simple, fee tail in the PCS state, the section 48 of land use that will operate to make it right of occupancy. So the purport of what I've said in these last two sentences is that states outside PCL had actually amended their law to say that such estate when created would be given right of occupancy. But they are saying that even though PCL has not made the same amendment as those other states have made, what has happened is that the provision of section 48, which says that I have not come to abolish any law, I have not come to throw out to make any law invalid. But what I've come to do is to make sure that those laws that are existing before now will be made to operate as long as they conform with the provisions of the Act and they conform with the intendments of the land use act. So by virtue of that provision of Section 48 saying that, oh, I will retain you as long as you conform with the provision of Section 48, so as long as you conform with my intendment, as long as you conform with the provisions of land use act, I would amend or more or less create an effect of right of occupancy when you are trying to talk about fee simple, fee tail in the western region of Nigeria. Now, something related to it is that I am not sure whether I am supposed to teach you this co-ownership or not. But because I could see that it's also kind of interwoven. It's interwoven with what's it called? It's interwoven with it's interwoven with the doctrine of estate. So let me get clearance from my professor whether I'm supposed to teach you or not before I would delve into it. I wouldn't want to go beyond the limits that has been approved for me. So, I have a number of professors appearing with me in this course. So if it would be better for me to hold on and get approval that it is part of what I'm supposed to teach you. If it's not part of it, then that means that by Tuesday, another professor will come to teach you. But if they say it's part of what I should teach, then I will teach you when I come on Tuesday. But the summary of it is that co-ownership and joint tenancy, co-ownership, which is broken to joint tenancy and then, and then tenancy in common, they are also related to doctrine of estate. So it won't be a difficult thing for any of the landlord teachers to just, move on, whether it is me that come to teach you or whether it is Professor Utubu or any one of them. So let me get that clarification, and then we'll come back on Tuesday to discuss it, and then that will take us to what will be the relationship between I want to end this lecture so that I can attend to. Did you all get me? Hello? Hello?
Hello, sir.
Okay, did you hear what I said? What last thing I said?
You said you wanted to confirm if you're supposed to take us on co-ownership, and then if you are, you come back on Tuesday.
Exactly. So if I'm not, then Professor Tubu or whoever among the professors is assigned to take it will come to take it. So on that note, I will see you on Tuesday.
So before you go, sorry, I have a question.
Yes.
Sir, can you please confirm about the restrictions to conditions? Can you please confirm if they apply to all types of estates or just to fee simple?
Okay. Well, no, it applies to any estate that is capable of being transferred, whether fee simple or not. Although you see that this one, the reason why we use fee simple is because fee simple is wider than all of them. If you have a fee tail and you're saying that, if you have a fee tail and you're saying that, if I have a fee tail and you're saying that I should conform with a condition that conflict with the interest of the community, it will not be possible. If you have an interest and there is something uncertain about a condition which is whether in expression or in operation, it will also be applicable. If you are saying that my fee tail is such that will be against a cause of devolution, when, for example, when I die intestate, or that saying that where the condition renders a fee simple estate liable to be defeated if the tenant dies intestate, becomes bankrupt, because even if it is fee simple, or if it is fee simple, if it is fee tail. Now, fee tail, the difference between the two of them is that the fee tail, the difference between them is that fee simple says that both ascendants and descendants can inherit. Are you getting my point? So, but for fee tail, it's saying that it's only my descendant can inherit. So when you say that I die intestate, it's still applicable to it. Of course, when we talk about fee simple, when we talk about fee simple too, you can also enjoy the rights that a fee simple person also enjoys. For example, if that thing is telling me that I cannot dispose. If it says I cannot dispose, even if I have a fee simple, it doesn't conform with the rights of a person who has an entailed interest in the land. So because entailed interest in land makes it possible for you to do what? To sell, to do other things, enjoy the way you want to enjoy it. Only that it limits the line of people who could inherit. So for me, I feel honestly that maybe the author is just using fee simple for for the purpose of achieving more clarity. Because if you look at fee simple and then fee tail, they are both inheritable. Inheritable because to the extent that the one says that it's only your descendant, while the other one says that your ascendants, your descendants, and your how do I put it? Relatives who are not descendants, who are not ascendants can also inherit. So those features that makes the two of them to be inheritable makes these conditions to be applicable to them. So for me, I feel that it is applicable, and that the author is just only used fee simple for the avoidance of doubts. So although what in summary, what whoever will be coming to teach you will be telling you the implications of joint tenancy, and then common tenancy in common. The joint tenancy, of course, those unity, like the absolute unity, like unity of time, subject to unity of time, unity of title, unity of possession, subject to other conditions. But don't let me go into it so that I will not be overstepping my bounds if it turns out that I'm not the one to teach you. Have I made myself clear? Hello?
Yes, sir. Thank you, sir.
Yes,
All right. All right. Thank you very much.